All right, David Parsons here, Lawyers in the Attic. We are at the law offices of Bamieh and Smith in Ventura, California. Ron is starting a case that we talked about on the podcast. You said it's going to be a tough case. Today was day one of the trial. How'd it go, Ron?
Uh, Rough day. The judge in this case is a former prosecutor and is new to the bench, and I think he still has a very prosecutorial brain, and he wants to gut our defense on a theory that my client's mental state's not relevant to the crime charge, which on its face is ridiculous because it would be. The case is tough enough. But to say my client's mental state when they have to prove his mental state, he was in the mind where he knew or should have known that his actions could cause great bodily injury or harm to somebody, uh, is the premise of the liability under the implied malice. And to say here's why he did not have the mental capacity to form that type of intent is not relevant is something I really didn't expect from any competent judge.
um, Give us the context of what's happening today. This is day one. What is this? Pre-trial motions? Are you selecting a jury yet? What's going on with the overall context?
Usually when we try cases like that against your first day is about calendaring pretrial motions, motions in limine, motions to limit the evidence of one side or the other, and scheduling and how we're going to schedule out the trial. And then, for example, we have to schedule now a hearing involving our mental health expert who has to come in and testify without the jury present so the court can hear his testimony and I can make a record as to why his testimony would be relevant and why that relevancy is important to the ultimate issue the jury is going to decide. So we will do all that here shortly. Tomorrow, for instance, what we're going to do is hardship jurors. Hardship means that you basically find out who can serve for it'll be until May 1 and who can't. And then we are going to bring them up to the courtroom, 75 at a time, and find out now that we know they can they serve on a case like this? A lot of people are going to have issues when the case involves the death of two people involved with an intoxicated driver, and whether or not the simple question is, can they be fair or not to start with? Like, is there anything that prevents them from at least saying they can be fair?
What are the types of things that would prevent them from being fair? Is it just that they've had a direct experience with intoxicated drivers and people dying in car accidents, or is it other things too?
It could be that for sure would prevent somebody from being fair. Somebody who says they're too emotional, they lost a loved one recently, they can't handle the death, they lost a child before, this involves the death of a kid, would be something that may affect them or their ability to hear a case like this. It could be a variety of reasons. It could be even that the defense attorney is too good looking and he's distracting to me. Hasn't happened yet, but one day maybe.
Wouldn't the prosecutors want someone that like that though? In other words, are you going to wrangle over this process those types of jurors?
We don't usually wrangle in this stage because this is the ones that are clear that nobody would wrangle over. The next process after that, in terms of like, are there something that prevents somebody from even hearing this type of case for whatever reason, and you'd be surprised how people will tell you that, is voir dire, where the attorneys get up and question the jurors, and we try to show there's a bias or cause that may prevent somebody from being fair or not fair, or rendering a verdict based on the evidence, not on emotion or what they think of the law or whatever. And so that process can go on for a couple of days, and then each side can use what they call peremptory challenges. We get 25 each. So
25. Does
yeah,
this seems like a long process?
it can be. My guess is we'll be picking a jury all week is what will happen. But the other fly in the ointment is that the judges, the courtrooms are all filled up in Ventura. So we just sent out today, we being Ventura County, I think 5 or 6 jury trials. So we filled up a lot of the available trial courts. What that means is that there's certain rights that defendants have to have hearings within a certain time. Well, so for instance, tomorrow we can't start until 10:30 because the judge has to do a preliminary hearing. He has to be available to do preliminary hearings, and all the judges do. And my guess is, since most of the cases that went out today are long cost cases, 2 weeks or more, that we're not starting a lot of our trial until 10:30 or 11 o'clock every day, so the judges can do preliminary hearings on other cases. Typically, when you get sent to a trial courtroom, that trial judge just hears your case, nothing else, and we just plow through it, and we go 9 to 4:30 every day, with an hour and a half for lunch. That's probably not going to be the case with this case right now at this time.
How long would you expect a typical murder case involving or murder trial involving intoxication and a car? How long would you typically take to do such a trial?
You mean with a death involved too?
Yeah.
Well, a lot of the cases you're contesting a variety of different things. So some cases you're contesting, hey, my client wasn't even driving. Some cases you're contesting, hey, look, uh, the the accident was not his fault. Okay. Some cases you're contesting that, look, my guy had no idea that this accident could possibly happen, whatever it is. In our case, and what I try to make clear to the DA, and since this is going to be heard afterwards, what I'm trying to get the DA to believe is that we're going to go as simple as possible on this case, and that you should just get your case tied. I'm not contesting anything. I'm trying to get her to reduce her evidence. So that's my goal. Okay. For her to think that since I'm not contesting much, I don't have to put on much. Why would I want to do that? Is because the less evidence a jury hears, the better it is for us in general. Not that they're going to hear so little evidence they're going to acquit them. That's not it. I just want the case to appear a lot smaller than it is to the jury, and the DA decides that, and so I just lay it out there that, look, I'm agreeing to everything. I filed a trial brief saying I agree to everything. He was intoxicated. He was behind the wheel. It was his fault for the accident. I'm not contesting any of those issues. And the people died as a direct result of this accident. I'm not contesting anything. Okay. The only thing I'm contesting is that he knew or should have known that driving intoxicated at the level he was could have caused death or great bodily injury. That's it. That's all I'm contesting. So we can just, I'll stipulate to whatever you want to stipulate to. Let's just get this case done in a reasonable amount of time because we don't need to do much.
Speaking of reasonable amount of time, this case has been going on since 2020. Was the accident occurred in 2020? It's 2024. How much longer do you anticipate? Is there like a light at the end of the tunnel with this trial?
Yeah, we're going to end this case. We'll have a verdict by early May, and he'll be sentenced within a month of that. If the court maintains its ruling that my expert can't testify, or he doesn't think my expert's testimony could be relevant, there will probably be an appellate process that would take a year to year and a half, because I think we win that appeal, honestly. So, but that's down the line. Right now, I have two concerns. One is I'd like to get this expert on the stand so we have a shot at getting the verdict. Two, I'd like to bluff the DA into asking for the gross vehicular manslaughter charge. Close to doing it now, and the DA now is thinking about doing it, whereas before she wasn't, but she hasn't pulled the trigger yet. So we'll see. If I can get her to do that, then we have a chance. Not a great chance, but a chance.
All right, Ron Bamieh, thanks for the update.
Hey, thank you.